All right, good evening. This is the call to order for the Chesapeake Beach Board of Appeals, October 21st, 2024. Or I will go quickly. Here we are today to do some administrative business, meeting minutes and comment receipt, at which point we will move into Mr. Pounds' presentation and then follow up with questions for Mr. Pounds if time allows. As always, we start with a roll call for board members. I'll go around. Please answer if you're present. Mr. Richard Birch. Present. Mr. Paul Doherty.
Present.
Ms. Amy Everett.
Present.
Mr. Stephen Sharp.
Present.
And Mr. Jody Hoonstar. We have a quorum. First item on the agenda is the approval of the meeting minutes for 2023-03 for the August 19th sessions, both open and close. Did anybody have any changes, edits, problems? In that case, I would entertain a motion to approve the minutes.
I will make a motion to approve the minutes.
Do I have a second?
Second.
All in favor?
Aye.
All right, the motions are approved, or minutes are approved. Sharon, have we received any public comments to be entered into the record?
Yes, one from Rita Hayes.
Okay, if we can get that on the record and make sure both Mr. Pounds and Mr. Blitz have a copy of those comments. We've done these announcements before, so I'll go through them quickly. We'll be doing 2 hours tonight. Oh.
We have the closed session minutes that.
Oh, I did them. Sorry, I did them together, but we can do it again. I thought I did them together. I guess not. Okay, I'll entertain a motion to approve the closed session minutes.
I'll make that motion.
Do I have a second?
Second.
All in favor?
Aye.
All right, motion, meeting minutes are approved for the closed session. Okay, so 2 hours tonight. We'll end at 8 p.m. Any questions or comments should be directed to the board or legal counsel here. If we get to the point where we are going to allow questions of Mr. Pounds, I will indicate to the gallery when it is time for that. The order of the agenda for the next session or two will be town staff testimony and evidence by Mr. Pounds, questioning of town presentation by any parties of record, at which point we will close the meeting, and then the following meeting will take testimony and evidence by person or entities whose rights are impacted by the appeal. Those will be members of the public. So there will be no public comment tonight. At the conclusion of Mr. Pounds' presentation and the questioning, we will hold a dedicated meeting to receive public comment. This will be announced both in this hearing and via an email, at least from the town. Okay, that's it for the announcements. We are on a continuation of case 2023-03, Rod and Reel Incorporated, Donovan Estates LLC. Consider an application from Rod and Reel Incorporated, Donovan Estates, 4160 Mears Avenue, Chesapeake Beach, for a decision on interpretation or alleged error to Article 629023, 29031, A1 and A6 of the Chesapeake Beach zoning ordinance and C309, C310, C311 of the Chesapeake Beach Town Charter. Applicant requests the Chesapeake Beach Zoning Board of Appeals to, quote, order the zoning administrator and planning and zoning commission to immediately commence and prioritize the processing and review of the relevant site plans submitted by the Rod and Reel Incorporated, Donovan Estates LLC, and that the zoning administrator and planning and zoning commission be ordered to apply the zoning ordinances in effect as of January 29, 2021, when their applications were submitted, and for such other and further relief as the nature of their cause requires. At this point, we will move to Mr. Pounds. Take it away.
Okay. Mr. Chair, members of the board, good evening. As you know, my name is Todd Pounds, and I represent the town of Chesapeake Beach in opposition to this application, which is in essence designed to construct houses in which has been designated in an area which is a floodplain. Mr. Woodburn, as the applicant's engineer, and also Mr. Donovan, fully admit that these applications are in the floodplain. And just to make sure the record is clear, floodplain is indicated in an area that is expected to flood. Early on in these proceedings, and Mr. Chair, just to let you know, I'm sitting down because Mr. Blitz, I think, is issues, so I told him I wouldn't stand up there, but that's it. But early on in these proceedings, the chair made a comment. We generally do not handle this type of matter. And I thought that it was very telling for these type of proceedings, especially in this case, which has been going on for approximately 35 hours. So throughout this time, at the beginning of this meeting, as happened tonight, the chair stated the standard of review of the Court Board of Appeals. And just for the record, I'm going to maybe paraphrase a little bit, but obviously the chair's introduction is going to be more telling and more applicable. This standard is indicated as basically that the Board of Appeals may pass an order requiring the zoning administrator to accept the applications which are the subject of these proceedings, and also have these applications reviewed by the Planning Commission on an expedited basis under the law prior to the adoption of the comprehensive plan. And I appreciate I may have paraphrased it a little bit, but I got pretty close enough. And there's been many hours of what I'll call testimony to arrive at the standard. Now, we started out, and everybody, I think, can agree that the court would have good 100% jurisdiction to hear this type of case. And we started out in court. But the applicant wanted the Board of Appeals. We are here because they're the ones that wanted the Board of Appeals as opposed to being in court. The question is, why? Why was the Board of Appeals chosen over a jurisdiction which everybody fully knew was applicable? I'll leave that for later on. But what's important is I never agreed to that with the court. The court case is still pending because I never agreed to any of this, and that will be, viewed for subsequent actions. Now, you've been hearing quite a bit over all of these hours about I had an application that was to be filed, and that the application was here and ready, and it was not accepted. I think it's important, and I want to make sure that indeed for the record is clear what it means to have an application, because at some point in time, what does it mean to have property rights associated with that application? Or is it just an application? Because without the property rights associated with the application, it becomes less and less as important, as Mr. Blitz has said many, many times, that he has the application. So what does it mean to actually have property rights with regard to the application? And that is under what is known as the law of vesting. In other words, at what point does this application become vested so the developer has his property rights that cannot be changed? Well, prior to 1972, and I've got these cases here, which I'll submit them, for the record, if you like, at the end. But prior to 1972, the standard was that the developer must be issued a permit. Not just an application that has not been accepted, but actually have a permit, which indeed has been reviewed and has been accepted, and a permit being issued. That's what it was prior to 1972. In 1972, in the court of Rockville Fuel and Feed Company versus Gaithersburg, the court changed that. Said no, for vesting rights, you have to have not only a permit, but you also have to have begun construction. So in other words, so obviously these applications are absolutely nowhere near this standard that is set forth by the court in 1972 with regard to what the law was at that time of a permit and beginning of construction. That opinion was further supported in 1975, in which the case of County Council of Montgomery County versus District Land Corporation, in which the owner and a developer got his permits, okay, and then it began expending fees for engineering fees, okay, and development fees and development applications. And he spent over $1 million of his own money for these development studies and plans for the development of the property. And all of a sudden, the local jurisdiction changed the zone on him. So he said, no, I have to have some type of right because I've just expended $1 million. And the court said, no, the standard is, and we've elicited it, vested rights means a building permit and began construction. Then in 1996, in the town of Sykesville versus West Shore Communication, that developer said, okay, I've read the law. I understand what the law is. And he had a large piece of property. And then in the back of the property, in the woods, he cleared out an acre of land and he began construction. So all of a sudden he had his permits and he began construction in a rear area of the area, and the local municipality changed the zone. He said, no, I have complied with the law and I've been with the law. And because it was in the woods, the court then changed the rule as to what it is now, to not only do you have to have the permit, not only have you have to begin construction, but that construction has to be visible to the public. And again, I'm happy to give you those cases for you to review at your leisure. But now that is the standard: permit, construction, and visible to the public. That's the standard in which somebody has an actual property rights, with regard to applications. This testimony of, well, I have an application, has no absolute applicability to actually having property rights, to actually having a right to that property or to those applications as it's being elicited. And just for fun, I've also included a case of Talbot County versus Miles Point, which is held that the Board of Appeals cannot overturn decisions of a town council. But I'll give that to you just for your review also. So basically,
Mr. Pound, what case was that?
and I do have a copy for you, Mr. Sussman. It's Talbot County versus Miles Point, 415 Maryland 372, Atlantic 3rd, 2 Atlantic 3rd, 344, 2010. So basically, ultimately, the Board of Appeals is looking to issue an order that will say to the zoning administrator, here, take these plans. That's the, now I'm going to, for the purposes of this presentation, I'm going to ignore the second part of the standard in which you've been reviewing of, that it will go to the Planning Commission for their review, and that in essence, the Planning Commission will have an expedited hearing under some other law. Right now, I'm going to ignore that. Basically, the order in which you're being asked to apply is that to the zoning administrator, here, take this. Well, just is to let you know, the zoning administrator is going to say, no, I'm not going to take that, because the Board of Appeals does not have the authority to tell me to do anything. The Board of Appeals doesn't have the jurisdiction to tell another town official to do anything. And especially the town law is what the town law is. And if the Board of Appeals wants to try to change the town law with regard to these applications, they can try, but it's the zoning administrator is not going to follow whatever supposed law that the Board of Appeals thinks that they may or may not have, as well as the instruction of the town council that she is not going to, the zoning administrator is not going to accept that order and accept these plans. That's going to be interesting.
Yeah. Mr. Counts apparently is testifying about what the zoning administrator, a decision the zoning administrator has made about whether they would, if the board issued the order that we requested, that they would reject it. That would need testimony.
I can tell you that let me change that to please you. I am telling you what I think is going to be presumed as to what's going to happen. So obviously, I don't have a crystal ball, but I have an idea as to what's going to happen. So that's what my understanding as the probability is going to happen, if it satisfies your concerns, Mr. Blitz.
Please continue.
So here we are. So it's basically it's taken 35 hours to, in essence, for the board to come back and in essence pass an order for the zoning administrator to say here. And so we will see what happens with regard to that. Now, earlier in the proceeding, a number of letters were submitted by town officials. And those came from the town council, from the zoning administrator, and also the planning commission. And what happened was there was a lot of consternation going on. Why is Todd Pounds doing this? Why is Pounds doing that? Why has he submitted these? That's an ex parte communication, which it isn't, but at least accuse me of the right thing. Okay. That came out but everybody was informed. Now I'm going to tell you the reason that was done, because I wanted to make sure that this board was completely aware early in these proceedings, many months ago, many meetings ago, that in essence you were informed specifically by the town official, that the town council, the zoning administrator, and also the planning commission, that you don't have the authority to do what's being asked. So we're not going to get, I could have easily waited till tonight to introduce all of those records, but I wanted to make sure that you were given all of that notice way back when. You can yell at me all you want to, don't care, because I wanted to make sure that the record was clear, that you were informed many, many months ago, many, many meetings ago, as to what the law was and as to what the others individual that Board of Appeals does not have this authority. Now, so it is undisputed that the town council has issued ordinances and resolutions to protect a particular issue in a way that the Board of Appeals believes that they have the power to overrule the town council and those decisions. And it is apparent that the Board of Appeals believes that it has the authority to overrule the town council. Was indicated in the record and from the town officials, that is untrue. Also, if indeed the Board of Appeals believes that it has the ability to overturn various laws for this application to have houses being built in a floodplain, and again, the floodplain is based upon the testimony of the applicant's own expert, then also it is important for the Board of Appeals to change other laws and in essence to veto other laws which have been passed by council, which are going to affect this application, including the Coastal Resiliency Plan and also the Critical Areas Plan, which also must be changed because those will also have an adverse effect on this application. So here we are in a situation in which it is presumed and believed that the order from the Board of Appeals to the zoning administrator is going to order that person to do a particular thing, and that person is not going to do it as what is believed is going to happen. Now what? Because if you simply order them to say here and they say no. So we have a situation, and it appears one of the primary problems with regard to this proceedings is that it appears that there's only a few people that believes the Board of Appeals actually has this authority. Obviously, Mr. Blitz believes that you do, but the rest of the board is sitting up on the dais. We don't know. And I guess we'll make that determination with regard to the issue and the order that's ultimately issued. Excuse me. So I think, obviously also as indicated in an earlier letter, there's been a lot of discussion with regard to a moratorium and what should be appropriately, done. What's interesting, and this is going to be a complete side note, this is completely off side note, but, Mr. Sussman and I were at a lunch the other day, and the irony is that the chief judge or the justice that was there actually began discussions about resolutions and ordinances and their applicability. And I started to call her as a witness, which would have been fun. But what we are doing here, it is certainly, so with regard to where we are, and as part of my presentation, I'm finding it hard to believe that we've been here for 35 hours and spent many, many thousands of dollars in town resources not to, in essence, have some type of order being issued. Indeed, that could have been stopped earlier on, but it was not. One of the things that Mr. Blitz has been saying many, many times is for the board to issue the permit. Issue it. I mean, I've said it many, many times. I mean, if you think you have that authority to do it, feel free to do that, okay? And just to let you know, and I want to make sure you understand with my old hat as a zoning lawyer, when you issue a permit, it means you become liable. You're the one that becomes liable. If you issue and you sign off on it, you become liable for that application. So, and obviously since the Board of Appeals is not an entity, sign off on yourselves, and these houses that are in a floodplain that in essence get flooded or people that are harmed, they're going to go after the people that in essence sign that permit. Nothing can stop you from doing that, okay? The town's not doing that, okay? But indeed, if Mr. Blitz has told you many times throughout the proceedings, you have the authority and issue the permit, do it. I mean, sign off on yourself and please feel free to do it yourself. So So now the questions have risen as to whether the board's actions are in essence to overrule a particular law or actions of the town council, or the perceived ability or the power to overrule the town in the way it acts, or whether indeed this is a misrepresentation as to the public. That's what scares me, okay? Because if indeed that there has been an idea and representations by this board that you have the authority to overturn these actions by council, and the council's actions are law, okay? That is done. So now, if you indeed have, can make this representation through whatever mechanism in which we've been sitting here for a long time, and we're going to be talking about the powers in which you've been told you have. Indeed, if you sit there and say, well, we have this power to do this, the question comes into, is that a misrepresentation to the public? Now, and so why I care, and I'll be candid, I really don't care what happens to the board. I care what happens to the public, because as I've said many, many times, I have been charged by the town council, you protect the public. And so that's what I fully intend to do. Now, and again, to let you know, as you know, and I've stated, I'm the town attorney for the town council. If indeed somebody came to that dais during a town council meeting and said that I think you have powers that the town council does not have, I'd have stopped them like that and said, no, the town council does not have authority to do that. The mayor would have stopped them like that and said, no, the town council does not have the authority to do that. The council would have said, no, the council does not have authority. But the Board of Appeals chose not to do that with regard to all going through this entire proceeding. So let's go over exactly all the powers that you've been informed, and I've been keeping track, which has been sort of fun for me too. So basically, the Board of Appeals including that you can order individuals to engage in acts. So it's interesting because, when you're dealing with variances or you're dealing with property, that's one thing. But now when you're being ordered individuals to actually engage and tell them, an individual, what you can do, that is something that even the courts are very limited because it's very specific as to what they can do, but the courts have that ability. But you've been informed that indeed you can order individuals to engage in acts by telling the zoning administrator, you will do something. Now, also, you've been told that you have the power to order town officials to engage in acts by saying that the zoning administrator and the planning commission will do a particular act, as well as you will overturn or laws that have been passed by the county council. Again, that is a very specific law, and that is something that you simply do not do. Next is power over administrative agencies. That in essence, you're going to issue an order to tell the planning commission what they can and can't do. That they will, in essence, hear a case on an expedited basis, as well as the law that they will follow. And in essence, that you will tell the administrative agencies how to hear cases. Next is power of the Board of Appeals to tell the administration how to rule on cases. Well, there's no sense sending it there if you don't tell them how to rule, because otherwise, what's the point of history? So it's presumed that in this instance, you've told them how to rule on that case. And then powers to tell the administrative agencies that they will hear the cases on an expedited basis. In essence, you will tell them when that they will hear the case, not only hearing the case, but also doing it. Powers to require them to follow a particular law that is not the current law. So in essence, instead of them advising that in essence, they're going to follow the law that they think is appropriate, no, you're being told throughout this that indeed you're going to order them to follow another current law. Next is the power over revenue and taxation authority, which is interesting because this document here that was introduced by Ms. Hayes, and also I've got a document here in which as I thought was introduced earlier by Mr. Blitz. So basically, as indicated by Ms. Hayes, and also that in essence, there's a dispute with regard to fees and connection fees with regard to the usages of water and or uses of the sewer. So Ms. Hayes, in which you've already introduced that into the record now, and I'm going to be introducing, which was a letter from Mr. Blitz, that in essence discusses this water and connection fees. Now, why is that important? Because in essence, this is a public document which has been submitted before the town council. My clients reserves the right to appeal first to the Board of Appeals. So it's interesting in that, in essence, now the Board of Appeals has new rights with regard to connections and the fees associated with those connections, in which I don't know if you even knew that you were being told, but it's being represented because it is now in the town record that somehow the Board of Appeals, according to Mr. Blitz, has that ability to review these connections with deal with fees. And also you've introduced the letter from Ms. Hayes, which in essence also has to do with fees.
I did not make the argument to anyone that the Board of Appeals had the authority to review EDU counts. You're having a letter described to you that was submitted as an ex parte communication and has not yet been entered into the record. It should be that step should go first before we discuss what I say about it or my opinions. That's why I'm objecting. Mr. Pounds is free to make all the arguments he wants, obviously, about that letter. I'll have a rejoinder. My point is he's making a bunch of arguments about something that I said that hasn't been submitted to you yet in the record.
Would you like to enter that letter?
Oh, sure. And especially, and I was going to introduce it anyway, but and again, this dealt with, just so the record is clear. Right now, the only thing I was talking about is these additional powers that apparently you're being told that you have, which is a question that you don't. So
You just have one copy for the board, or? Oh, I thought this was the additional thing, the letter from Blitz you said you were submitting? Oh, that's something different. Okay.
So at this point, I'm going to object to the introduction of this as an exhibit.
Well, it's a public record. I mean, you can like it or not, but it's the town records.
If I could be heard on the objection. Mr. Pounds is trying to introduce a letter about an issue that has absolutely nothing to do with the Board of Appeals case that you're hearing. It is a separate zoning violation for different property, rod and reel property, and a contest about the EDUs. This is completely irrelevant to this case and should not be considered. It was objectionable when it was submitted as an ex parte. It's objectionable now. It's simply not relevant to any aspect of this case. Doesn't touch the properties, doesn't impact the properties. And Mr. Pounds is making, well, I'll leave it there for the objection as to the exhibit. If you're going to admit the exhibit, then I've got other arguments. But my point is, this is bringing in something that is completely irrelevant to this case.
I'd like to ask Mr. Sussman to review this.
Well, I can tell you, if it makes it easier, Mr. Sussman, I can tell you what. The only thing I care about is my comment that powers over revenue and taxation, which indeed Mr. Sussman put in his letter, Mr. Blitz put in his letter. So whether you want to introduce the letter or not, I really don't care. Okay, but what important to me is that's what was said. It's in the town records, and to make sure that indeed the board is informed that the board is being represented. That indeed you have that power also. So,
Except that it doesn't say that. Let me explain the context just so you understand. This Rod and Reel, for the Rod and Reel development property, received a notice of violation for for a series of things, some of which were zoning and some of which were for a dispute about EDUs. I responded, and in this case, I was responding about the fact that I'm providing the evidence against the EDUs, and I'm saying with respect to any violations of a zoning ordinance, I'm reserving the right to appeal to the board, because that's literally the power you have, is if there's a zoning violation, somebody can come and appeal this to the Board of Appeals. All I was doing was saying that, but it has nothing to do with this case. It's merely saying you brought a series of things, some of which are zoning violations, in the notice of violation. We're merely preserving our right to, rather than send this letter, also take the case to the Board of Appeals should we need to. My point is, this is about a different property from the properties we're dealing with and has nothing to do with the case. It has really almost nothing to do with the Board of Appeals power. Literally, all I'm doing is saying we reserve our right to go to the Board of Appeals if we have to in this other case.
We're going to allow this into the record as stated and not as a power of board as what's been represented here. So please continue, Mr. Pounds.
okay, so next, the power which has been discussed is the power to determine taking of property issues. And what's interesting, we had taking of property issues, which is interesting. We had almost a full hearing to discuss whether indeed this was a taking. And I think it was interesting in that counsel for the applicant came but refused to answer questions, with regard to any of that, which is interesting too. Now, Mr. Sussman and Mr. Blitz fully know what the term taking means. And taking is a very unique term of art in the law. It means that in essence, that nearly all the property rights and ability have been taken from the owner, which is interesting because now we're not dealing with his ability to do various things, because in essence, it's been admitted and also been determined that we're talking about property which is in the floodplain. So any limitations on his property would be more as a result of environmental or that, as opposed to any taking that in essence was subject to any rezoning of his property or actions by council, as indicated by the cases which I said earlier. We are a long way from, as the law currently exists, permits being issued, construction beginning, and construction that is in essence also visible to the public. So that application generally is not at all applicable. Next is general powers and authority to overturn the decisions of town council. So basically, in these applications that in essence, I'm going to presume that you're going to issue an order, because we've been here the way we have, that in essence, in order to move forward, this board's also going to have to make sure that indeed overturns other laws which have been put forward by the town council, including coastal resiliency and laws with regard to critical area. Because with regard to that, overturning those laws, in essence, your order doesn't have much effect either. Which was interesting is per Mr. Blitz, issue with regard to constitutionality. That one I put a little smiley face by, because in essence, the Board of Appeals, in essence, is being told to review Supreme Court cases or cases from the Supreme Court of Maryland, and in essence, to make that determination as to what is appropriate. Most circuit court judges don't do that. Most circuit court judges will not overturn or impose their opinions upon, especially upon, any case, upon if indeed the Special Supreme Court or Supreme Court of Maryland makes those issues of the constitutionality. But you were being instructed, and it was earlier on, that indeed the Board of Appeals needs to also address those issues of constitutionality. Then, in a recent hearing, that in essence, that the Board of Appeals is exhausting the administrative remedies in order to eventually get to court. In essence, and that's the law, is that in essence, when you have remedies, that in essence, you are required to go through an administrative counsel or administrative agency before you can go to court. But we started in court. I mean, this isn't something that, you need to go through an exhausting administrative agency. And I put 2 smiley faces by that one, because you're saying that we need to go through this process to get to court, when in essence, we started in court to begin with. So why are you being informed that indeed you have needed to do that in the first place? So again, and again, I'm going to reiterate it. One of the interesting things that has been said a number of times is that this board should go ahead and actually issue the permits. Well, again, I encourage it. Indeed, sign off on it, so and actually allow the applicant to begin construction of these houses in the floodplain. But in essence, as I stated, when you sign off on an application, if somebody gets hurt or if property gets damaged, the person who signs it is the one who becomes liable. So feel free. That will be a decision for the board. Now, earlier on in this process, we had a situation in which Mr. Blitz was sworn in. Excuse me again. And this causes me a great deal of concern. So Mr. Blitz was sworn in, and then during the process, there was an email sent to that in essence discussed the process of cross-examination of Mr. Blitz. And and during that process, which is in evidence, it stated that indeed Mr. Blitz was under oath unless he changed his mind. And that was an email from Mr. Sussman. He said, after my discussion with the chair, and in essence, unless Mr. Blitz objects to any questions, is what the actual phrase was. I saw that at the beginning when it was first sent, ignored it. But suddenly, and what causes me pause and concern, was at the end of the applicant's case when Mr. Blitz said, no, I've changed my mind. I am no longer under oath. I've decided that I was never under oath. And in essence, that I don't have that testimony.
Objection. I never said I changed my mind.
Okay.
I merely said I was not testifying and being cross-examined like a witness. And I explained the reasons why. I never said I changed my mind.
Okay, the testimony was I'm not under oath, and I was never under oath, and that's fine. Let the record state whatever the record states. But my concern is the appearance, and I'll be frank with you, and I'm going to be candid, that how did you know Mr. Blitz was going to do this? That's what bothers me than anything else. Unless Mr. Blitz objects to the question. This was done many, many months before Mr. Blitz decided that I'm no longer under oath. That in essence, and that is in the record, and I'm going to leave that up to you. But what concerns me is now, as soon as Mr. Blitz did that, this is a huge concern I have. I immediately said, I object, and I moved to strike. And then it was denied. That in essence, so Mr. Blitz turned around and changed his mind as to, well, I'm going to change my mind. I'll rephrase that to make it, he said, I am no longer under oath. But what is now the meaning of that testimony or whatever it is, because under oath, the people thought he was under oath, and then all of a sudden, not under oath because he changed it. So, and then instead of saying granted, it was denied. So I'm sitting here thinking to myself, there's no way they're going to deny it twice. There's no way he's going to do that. Again, that night, objection, move to strike his testimony, denied. So now we have a question out there of what's the truth? How is the public supposed to know what indeed throughout this entire 35 hours of testimony, except for the limited testimony of the other witnesses, as to what actually happened here and whether this is testimony or not? I don't know. But I have a great concern as to, in essence, what exactly happened. And most importantly, that misrepresentations were not made to the public. Because I can tell you there is absolutely misconduct that is worse, nothing worse than a governmental agency who makes misrepresentations and in essence spends the public. But that's, and I want to make, I'm not accusing anybody, but I'm just saying the appearance causes me pause, and I'm very concerned about the way that has proceeded, because who knows what that 35 hours of testimony was? Who knows? Nobody knows. I mean, what is it? Was it testimony? Was it not testimony? But what I do know is that the public was misled. So we have a situation in which which I'm presuming that there's going to be an order issued to tell the zoning administrator here. Yeah, and I'm also presuming that in essence, the zoning administrator is going to say no. So, you know, it's been said, you know, many times through various witnesses that this is a process and proceedings that belongs in court. Well, there's no dispute that this started in court. And in essence, it was Mr. Blitz who wanted this case to go before the Board of Appeals. But I think it's interesting in that right at near the beginning of the case, the chair said, we do not handle this type of matter. We generally do not handle this type of matter, which is an interesting how this is going to proceed from this point. So if indeed the court issues an order, okay, which I've stated, I'm fully expecting some type of order to be issued, because otherwise we've been sitting here for the last 35 hours and spent a tremendous amount of money. So, and the zoning administrator says no. Now what? So now what's going to happen? If indeed the board then tries to go to court to enforce this, well, then that means this whole proceedings was nothing more than a sham, because we were in court to begin with and we're here. So now we have to go back to court to indeed enforce powers in which you, in essence, did not have. Again, this as an attorney who's been doing municipal work for almost 30 years, this is extremely serious to me. This is exactly the type of thing that, in essence, I am told to stop. Okay, the town council has told me to stop it, to in essence protect the public. And based upon what has happened, it concerns me that there was an intentional spending of the public by the government. That I'm not going to put up with. But you do whatever you want to do, and we'll see. So what's also interesting about this is early on in the proceeding, there is a question about how the board is going to vote. Okay, in essence, many, a couple of the board members missed meetings, and as a result, that they missed testimony. So in essence, they can't vote because, and I can't disagree with Mr. Sussman's assessment that they can't go back and look at the video because the code doesn't provide that. I get it, that's fine. The problem is with Mr. Blitz's withdrawal of his testimony or withdrawal of his swearing in, and we don't know exactly what process that is. There's no reason why everybody can't vote, because in essence, you know, that is no longer testimony. There's no longer evidence, because in essence, there's no reason why they can't go back and look at that meeting that they missed and make that determination. So that's going to be very interesting. And I can tell you, either way, either if it's going to be 3 people or if it's going to be everybody else is going to be entitled to vote, because of where we are right now and because of the fact that we don't know what the testimony is or what indeed has been introduced into evidence or where it was, both answers are going to be wrong. Okay, however you vote, both answers are going to be incorrect because in essence, who's going to be right? I've never even heard of that before, that in essence, how are you going to handle that situation and how is that vote going to occur? So I can tell you either way, it's going to be unenforceable because somebody much smarter than all of us is going to have to review that to make that determination because now you've got an issue as to who can vote. Who knows? Okay. Now, obviously this is going to be going on. Okay, so basically, let's make sure I go over briefly how we are here. Basically, what happened approximately 12 to 14 years ago, permits were issued for this development. The developer didn't build pursuant to these permits that were issued. The permits were extended, but again, for various reasons, one way or the other, he chose not to build. So for the purposes of the proceeding, I'm going to avoid any issues that we discussed before about, Mr. Blitz and whether he was attorney for the board or attorney for the town, or ignore all of that. But what's important is, in essence, there was a determination that indeed the comprehensive plan was indeed going through the process. And again, there's no dispute by Mr. Woodburn or by the applicant, who both testified that indeed these properties are in the floodplain.
I just object, just to clarify, Mr. Woodburn, Mr. Donovan did not testify that all the properties are in the floodplain. Home Place is clearly not in the floodplain, not anywhere close to the floodplain. So lumping all the properties in together and this discussion, I'll address the floodplain arguments later, but I just want to point out that Home Place isn't anywhere close to a floodplain.
Then I can only state what they said in their testimony. Okay, but with that proffer, I won't object to that proffer. And so if I do say properties in the floodplain, let's assume that I also say that excluding the Home Place, but the rest of them are. So in essence, what's interesting is, so the applicant decided that indeed he wanted to prepare these applications during the comprehensive plan process. And according to Mr. Donovan, he went and talked to the zoning administrator at that time, who said no, that in essence, he's going to rezone it to take these property out of development. Mr. Donovan stated that indeed it never went to the Planning Commission, which the Planning Commission had an incredibly long process. As a personal opinion, it went on too long, but in essence, everybody got heard. Everybody, there was meeting after meeting after meeting, hearing after hearing, that in essence, and for the Planning Commission, and Mr. Donovan said that he never participated in the Planning Commission process. Also, it goes to the town council, and he met with a couple of the members who also stated they're not making any changes to the Planning Commission. So we have an issue with regard to, in essence, the question is, did he really take the necessary steps to protect his own property? Or was this the idea that I'm just going to file these applications and see what happens? I think it's, in essence, with regard to something that both Mr. Donovan and also Mr. Woodburn said, and with regard to their review, is the quoting term, things change. Unfortunately, in Chesapeake Beach, things change, especially in the last 12 to 14 years. And also after those applications, in essence, expired, 10 years go by before, in essence, he prepares these applications with regard to the comprehensive plan. So in essence, the comprehensive plan process goes through, and it's made its decision that that indeed the applicant really did not participate in the whole comprehensive plan process, except for to file these applications. So what is important here and and I want to be absolutely stressed and on the record of the importance of the Board of Appeals. The Board of Appeals plays a fundamental and vital role in the function of government to avoid hardships as they appear. That's what's important for the board to do. But what's important is, for those to make sure that people are not harmed by hardships when variances can fix this matter. But the problem is that that does not apply to applications for zones or changing the zones or overturning decisions of town council. So the question is, earlier on, the chair said, we do not generally handle this type of matter, which begs the question of why now? So there are two things that concern me, and I'm going to put them on the record. Number one is that in essence, the Board of Appeals is completely correct, that indeed you have all of these authorities and powers that in essence are outlined and requested by Mr. Blitz, that indeed you have the authority to do pretty much anything you want to and overturn the ability of town council and overturn any law that they've passed. I do not believe that. You've already gotten letters in the record, and also that in essence, you don't have that authority. The other part of this is that in essence, Mr. Blitz is wrong, that in essence, then the question is, what is the impression that you have in essence imposed upon the public? That becomes deadly serious, okay? And, I sent a letter a little while ago, I advise you to get your own lawyer. Oh, Todd's crazy, Pounds is crazy, and everything else. I would not want to be in that position, but that's completely your decision, because in essence, the Board of Appeals is the one who put themselves into this position. But so basically, the question is, what's going to happen next? And this is, again, my presumption as to where we are and where we're going. So I think the board's going to issue an order, because 35 hours, all of this time, all of these months, all of these thousands of dollars spent, I can't imagine an order not being spent. That's fine. Now, with regard to the order, it's going to have to be specific. It's not going to be, and I wrote down the word slop. It's not going to be, you're going to have to do details, not only the findings of fact, but also the legal basis as to how the Board of Appeals has the full legal ability to overturn council and again, to show these powers that indeed you're going to order the zoning administrator to take a particular act. And I'm presuming and believe the zoning administrator is going to say, no, I'm going to follow the law and the instructions of the town council and how you're going to enforce that. That's going to have to be in the order. So then, as I stated, once the order is done, then it's going to be given to the zoning administrator, who, again, is my understanding, is going to be rejected. So where does that leave all of us? With regard to my concern, again, is how has this been presented to the public? That's a great deal that I have concerns. So you've already been told, and I did it on purpose, that in essence, early on in the proceeding by the town council, by the zoning administrator, and also the planning commission, you don't have the authority to do any of the things which you are being told pursuant to standard to do. Now, again, I could have waited till the night. Could have waited till the night to do it, but no. I wanted to be able to look at you and say, you were fully informed. You had notice. Many, many months ago, many, many hearings ago, you were fully informed and chose to ignore it. And that's your option. But again, I wanted to make sure that indeed that is the reason that was done, is because that plan was done many, many months ago. So this is going to be, I'll be frank, for a lawyer, for my purposes, it's going to be fun to watch. I mean, like I said, I'm presuming an order is going to be done. I'm expecting an order to be sent. The zoning administrator is going to rejecting it. And in essence, you're going to have to show me the powers to enforce what you're doing. In essence, the zoning administrator rejects it, the town council rejects it. So now you have to go to court to say, no, court, we do have the powers to do all of this, when in essence, we started out in court. So the question is, if we started out in court, why don't you have the power to enforce it yourself? So again, that's where I believe we are and the town's position with regard to the case. So in essence, if you want to see these cases, would you like them now or would you like them later? Or I didn't bring enough for everybody. Would you like me to resubmit enough to everybody? That's completely up to you. Regarding the cases of dealing with vesting, in other words, at some point with regard to these applications, because what's important is, oh, these applications say I've got property rights. Well, no, you don't. Property rights occur in the recent cases. Permit, construction that's visible to the public. We're absolutely nowhere near that. And again, what's fun is another case here, which you can review, is that a Board of Appeals can overturn town council, which you can look at that, for fun also. But that is the town's presentation, again, with regard to the introduction of these. Would you like to do that now, or would you like to do that later? How would you like to do that? Would you want me to submit others to everybody, email it to everybody? Out?
Yeah, I was gonna say email to Sharon.
Okay, so I'm gonna give one copy of each of them to Sharon, and then I will email the rest of it to everybody else.
Wait, we're getting documents submitted outside the context of the meeting as exhibits? What
I
are
think
we
we're getting
doing?
the cases that Mr. Pounds cited just now.
It's physical copies right there, just not enough for the rest of us. That how's working?
Okay, so you're going to submit them to the clerk now so that it's in the record that they've been submitted, and then you're going to follow up with an email copies, digital copies? Is that what the idea is?
Passing it to Sharon will be good. Just get it, Sharon. We'll get the rest of it.
Acceptable?
And these are just court cases, right?
The record, I'm going to do this and then make the note, and then I will email you. It won't be tomorrow. Report out for tomorrow. We'll copy and copies of all the cases for everyone. I do have an extra copy if anybody would like to have that for the record, but I will be emailing that.
Okay, thank you, Mr. Pounds. Let's go ahead and take 10 minutes, or let's take 5 minutes, and we will reconvene for any questions for Mr. Pounds.
So, Mr. Sussman, I only have one copy of the Talbot County case. Do you want me to submit this and I can just reprint another one when I email that? Or how would you like me to do that? That was that case in which says the Board of Appeals can't overturn the council vote. I don't care. Whatever you want, however you want. I can submit it and just reprint another copy. Okay, so submit this? Okay. Four. Yeah, three dealing with the vesting issue and then one dealing with the other.
And how'd you guys do? I texted, I'll show you the text to Jen. She, I think we got common on last minutes, but we got common. Yeah. No.
Okay, we are reconvening for questions from Mr. Pounds. At this time, we will allow any parties of record to ask questions of the town's presentation. Questions should be limited in scope to address the information presented. Please step forward, announce who you are and who you represent, and enter your name and address on the sign-in sheet. You may then direct your questions to the relevant party. And the board may also ask questions as they see fit. Mr. Sussman, would you mind doing the blanket swearing in of all? I guess we should see. Is any member of the public planning to step forward and ask questions? Do we want to do? Are you planning on questioning? Okay, since we're doing this, we're still following the guidelines established during the May 29th session with Mr. Fisher. The line between cross-examination and clarifying questions isn't something the board feels comfortable delineating, but the board has decided to allow questions. If lawyers feel that this violates the professional code of ethics, they must use their judgment as to whether they can answer the question. If one or more questions are declined to be answered, the presentation will remain in the record, and the record will reflect refusal to answer. The questioner may proffer as to what questions would be posed given the opportunity. And I'd advise that if, yes, you may use your judgment. Go ahead, Mr. Blake.
Thank you, Mr. Chair. Mr. Pounds, you discussed that we had already gone to court. And isn't it true that we didn't go to court on the substance of this case? We went to court to allow this proceeding to even occur. That is, it was a proceeding of mandamus to have administrative relief, which is what we asked for. So we didn't ask to go to court first. We filed an appeal to this board, and you sent a letter saying we can't have it. So we went to court. Isn't that true?
What my testimony is that we were in court and that in essence, there's no dispute that the court has jurisdiction to hear all of this case, and that for some reason, Mr. Blitz didn't want a court. He wanted that in essence to come and have this board hear the case. That was the question that in the presentation as I do. And my question is, we were in court. You could have filed an amended complaint. We were there. Let's do there. Okay. And I never consented to any of this. So to answer your question, you are correct. But my point is, why? You know, if court can resolve this, why did you want the Board of Appeals so badly? That's the point I was making.
I just want to make it clear to the board. We originally came after we were denied after the rod and reel was denied site plan review and zoning permit review. We filed an appeal to the board contesting that. Yes.
Let me make sure. We will have a time for summaries and clarifications.
Yes, I agree.
I'd
This is
like-
kind of argumentative.
Yeah, make questions to Mr. Yeah,
Okay, no, that's fair. Mr. Pounds, when you sent the letter to the rod and reel, or to me, saying that we couldn't have this Board of Appeals hearing, at that time, were you representing the Board of Appeals?
I don't know what you're speaking of.
But it's in the record, and we submitted the letter. I don't, somebody.
We can discuss it later. I don't mind deferring that later, but I don't remember what you're talking about.
Actually, it might be faster for me to find it this way.
So if you'd like, we can reserve that to a future meetings as we are going to be back and we can answer the question later. That's up to the chair.
Take a moment to look, and if not, let's move along.
We'll just reserve that. Let's see. No further questions.
Thank you. Does any member of the board have questions they'd like to ask at this time?
Yeah, I have one question. Mr. Pounds, you made this statement several times that this board has no power to direct planning and zoning to take any action. The ordinance that empowers this board, 29032, gives us the power to decide on matters of interpretation or errors in an order by the administrator or Planning and Zoning Commission. So if this board were to decide a matter, let's say not this matter in particular, but let's say just hypothetically, would decide that the planning and zoning administrator incorrectly interpreted some provision, are you implying that this board does not have the authority to direct planning and zoning administrator to change his mind on an interpretation of a provision?
And I want to make sure, so basically, I think it's very interesting, the fact that the examples that you just gave were errors in the order of a zoning administrator, okay? That is exactly what the Board of Appeals is designed to do, to make sure that indeed, if the zoning administrator goes out there and makes a mistake or issues a decision with regard to a piece of property that creates a hardship, or that indeed the strict interpretation creates a hardship, which, as you know, is your standard, that in essence, that homeowner, rather than being stuck with that, with the absolute interpretation, has a place to go. That is absolutely what it is. But I think that, but I'm going to answer your question directly, that with regard to the incorrect interpretation by the zoning administrator. So in essence, what you've done is saying, okay, you've had the zoning administrator who believes that the town council is the one who makes the laws. They have made the laws. They have instructions from the town council as to how those laws are going to be interpreted. Now, your question is in essence, well, no, we're going to issue our interpretation of it. And now the zoning administrator is to interpret our belief and interpretation rather than the town council. I am presuming, I'm going to ask you to let me finish first. I am presuming, based upon what I understand, that the zoning administrator is going to say, no, I'm following the law. I'm following the town council. I'm following the instructions of the town council. That's my understanding as to what, and we're talking about your hypothetical, obviously.
Well, you're assuming here that that I'm talking about a particular instance. In other words, that this board might direct planning and zoning to, I don't know, ignore what's happened and direct the site plans to be reviewed under old ordinances. I'm asking in a general way, because you've made the statement that it seems to be that under no instance can this board direct the planning and zoning administrator. And yet we're allowed to decide on matters of interpretation. And if we decide that planning and zoning administrator has misinterpreted something, it sounds like you're saying that we cannot tell the planning and zoning administrator to change his mind.
And what's interesting is, and then I understand your point with regard to your hypothetical, but the problem with your hypothetical is it does not also add in the condition that the town council says otherwise. So now we are back to the point of the Board of Appeals believes that it can overturn decisions of the town council, which goes to my point of saying, at what point is that a misrepresentation to the public? Okay, now, and I'm going to finish answering your question too, because you mentioned that, and I think, did your question also include the planning commission and issuing orders with regard to the planning commission? Was that part of your question?
Yes, planning commission and the administrator.
I can't speak for the planning commission. Okay, I'm not here to speak for them, but I can tell you this. I think it will be amusing that in this instance, the Board of Appeals issues an order telling the planning commission to do something. Do me a favor, can you invite me as to when that meeting is? Because the planning commission will probably tell the Board of Appeals what they can do with your order. But I can't speak for them, but I think that will be fun to watch.
So if the planning and zoning administrator or commission issues an order and the Board of Appeals decides that or there's a misinterpretation involved in that order, are you saying that this board cannot reverse that order?
Again, could you repeat the question? Because your question was dealt with multiple people involved. And ultimately, I think the answer is going to be the same. But I'm going to ask you to repeat it then, because I want to make sure the record is clear as to what we're talking about, because I can tell you where we're going to go with it.
If an order is issued by the administrator or the Planning and Zoning Commission to a developer, say, and this board decides that that order was an error because because it was a result of a misinterpretation.
Sir, if I could stop you there, when you say an order was issued, who issued that order that you just referred to?
Planning and Zoning Administrator or the Commission, Planning and Zoning Commission.
Okay, so they're the ones that issued the order.
Yes.
Okay. And then you decide, can you decide, and I apologize, I want to make sure I understand it. So the question is, can the Board of Appeals, in essence, act to overrule the Planning Commission if the Board of Appeals thinks that the Planning Commission overruled something or made a mistake?
Correct.
You know, it's interesting. I think that's in my, if you want my opinion, or I think you better raise that with the Planning Commission first, because I'm not going to be telling what the Planning Commission what they can and cannot do in that instance. They are an independent body. They're an independent agency in this town. And in essence, the question is, do you have the authority to overrule that other administrative body is in essence what your question is. Okay. And you can ask them, but if they were to ask me, I would say, no, they're going to make their own decisions with regard to it. And, you know, in essence, and if town council says something different, that's going to control, in my opinion.
If this board has the power to decide, and that's what the ordinance says, decide on an order. And if that decision doesn't result in a change, what's the point?
When you say result in a change, what does that mean?
Well, again, getting back to, let's say the planning and zoning administrator issues an order to a developer. And that developer comes to this board and argues that the order was an error because of some misinterpretation. And this board decides that that order should not have been issued because of a misinterpretation. That we cannot go back to that, to the administrator to say, reverse the order, withdraw the order.
I want to make sure we understand exactly what you're saying, okay? Because in this case, it was not the zoning administrator, it was town council who issued the order. Okay, no, I'm sorry.
I am talking about a general case. I'm not talking about necessarily this particular case.
And I agree with you, okay? If indeed the zoning administrator has an application and he makes a decision, okay, that is the purpose of the Board of Appeals, is to have the public or the applicant make that decision as opposed to the zoning administrator's decision. In essence, to show hardship, or in essence, you would have the ability to, in essence, have them make that decision. Now, again, we're talking general, right? We're not talking about this case, because once you insert council, changes all the rules, okay? But the answer to your question is correct, because that's what the Board of Appeals is designed to do, is the zoning administrator, in essence, to have a remedy if they make a decision. But the problem is this: can you order the zoning administrator, which I think is what you are making that thing? Can you order the zoning administrator to take that decision? No. You would make the decision and overrule them, but you cannot order them.
We overruled the decision, but we can't change the decision by
No, you cannot order them to change it. You can overrule it, but you cannot overrule them to change it.
I don't understand the distinction.
Oh, there's a huge distinction, massive distinction, okay? Because in essence, they make a decision and then they have a question and then they go to the Board of Appeals in order to, determine if indeed there is a hardship, because that's what the board is. Establishing hardships. Let's say somebody has a deck, okay? And you guys see it all the time about somebody saying, you know, I've got a deck and all of a sudden and I have to put it 2 feet into the setback. Okay, and it's a corner area and it's no big deal. And the neighbor says, sure, I like my neighbor, go ahead and put the deck in there. The zoning administrator says, I'm sorry, all I can do is follow the rules. Okay, I don't have the ability to do variances. Then they come to the Board of Appeals and say, oh, there's a hardship, okay? Because this deck has a couple of feet that in essence, and nobody cares, now you guys are with the ability to make that decision. You can't tell the zoning administrator to change because they're required to follow the language of the law. Deck in the setback, you can't have it. But you guys can say, deck, okay, we'll move it over. What's the big deal? And then it can be approved. Can you order the zoning administrator to do anything? No. Can you make that decision? Say, yes, we're going to grant that variance? Yes.
We cannot order a planning and zoning administrator to withdraw an order.
Oh, no. I mean, no, absolutely
We can
not.
decide on an order, but we can't tell them to withdraw the order.
Absolutely. Because in essence, what you're doing is you're going to say, hey, you interpret the law however you want to interpret it. You can violate the law if you want to. No. If you want to do that, that's what your power is. Okay? You can't order somebody else to do anything.
I have no further questions.
Some questions and clarifications. You stated that the case that brought us all here is still pending because you didn't agree to it.
Absolutely.
Can you, we had an order to start this, so how is it still pending?
Oh, because I never consented to any of this. And the judge said, the judge wanted to dismiss it. And I said, absolutely not. Because if you dismiss it, it's going to require me to immediately file an appeal. Because this is my belief that this whole process was inappropriate and wrong to begin with. So it is still pending. Mr. Blitz and I have had 6 continuances, 5, whatever. We got another hearing coming up in November, which I'll speak to him about continuing that depending on where we are with that. So, but the case is still pending.
You stated also that several town officials had sent us letters, right? Saying that we didn't have the right to tell them what to do, paraphrasing, right? So if it were determined that the code, did say that, whatever else,
Code, what code?
or I mean, the ordinance, whatever, whatever our rule or whatever our rights are here, let's just say the legal interpretation says that we can. Are you saying that because a town official said we can't, that supersedes it?
I'm telling you, just say that.
Well, no, you were saying that individuals, town administrator, town council, you said individuals wrote to us and told us we can't.
On behalf of the council, that's right. Say individuals, use based upon who they are. That's right.
Right. I was just wondering if you felt that they had more pull than the legal interpretation of what is actually in writing. They might be the same. They might be the same. I'm just asking you because you told us because these individuals said so.
Have a legal interpretation.
I'm not saying that. I'm saying what you said is that these individuals told us we cannot, and therefore we cannot. Are they?
If you have a legal interpretation that indeed you have the authority to do that, okay? And if you read, the ordinances and so forth and the statute that, has been cited that we've been talking about in ordinance, okay, in nauseam, if you read it, it doesn't say that you have the authority. Okay?
You're not answering my question.
No, I am. But the question is, you're asking me to make the assumption that indeed legally you have the ability to do that. Legally, you don't. So indeed, if you think you do, great. Okay. Then I was going to say, what's going to happen is when you issue your order, you're going to have to, in essence, say, yes, legally, we have this ability and authority to do this X, Y, Z. Okay. It's going to come to me. I'm going to review it to make sure that indeed, in my opinion, that indeed you do have the authority. And then we're going to present it to the zoning administrator. Okay. But I'm not conceding at all that you have the authority to begin with at all.
Okay, that wasn't my question. My question was about the individuals, but
Okay, okay, go ahead. The individual.
no, I've asked and you have not answered, but
Okay, now please ask again and I'll see if I can do.
you were just stating that they said no, and therefore the answer was no, that we could not do this. So do they have, are they the legal say-so as to what we can and cannot do?
That's interesting. Okay, and you're saying that they said no, so you have to follow them. Okay.
That's what I heard you say.
Okay, and what I, in essence, am saying, that you have been informed that their position is that you cannot.
Okay,
So-
their position. Okay.
So the question then becomes this: if you engage in conduct that, in essence, when you have been fully informed, that in essence of that, and you decide to issue an order, okay, which can be viewed as harmful to the public, then the question is, with full knowledge as to what you've been informed by the town council, then I was going to say, I want to make sure you're aware as to where we possibly could be going with that. Okay, because you have been informed that in essence, you don't have the authority. Now, if you're saying you do, great, get some legal opinions from Mr. Sussman. Okay, because I can assure you, you ask me a question, I'm going to give you a direct answer. It ain't going to stop here. Okay, so it's going to be, yes, Mr. Sussman has the authority, and this board has that authority to overrule decisions of town council, which in essence is what this whole proceeding is about.
Okay, moving on. So you said that in regards to taking oath, Mr. Blitz changed his mind. When did that occur? You referenced that it occurred, but can you tell us exactly what point you're referring to?
It happened at a meeting in which he got up and he said, I'm not under oath. I was never under oath. And therefore I'm not under oath.
Okay,
mean,
I just thought we
I
might
was
have
at
that
that meeting.
specific. I understand. We all were. I just thought perhaps you had it in your notes as to exactly when it happened.
Oh, dates?
It was,
I
yes.
probably go through my notes, but off the top of my head, I don't remember that. But it was, I can tell you this, it was at the end of his presentation.
So the abilities that this group has and how we vote on different issues that come to us, when those are modified or created or whatnot, who is the final say so? This all happened before I got here, but do you have to sign off on all that for the legality for the town's sake as to what happens in this group?
What it basically ultimately can do with you. If the Board of Appeals is going to issue an order and it's slop, okay, I'm not going to sit there and listen to slop, watch slop.
What I'm asking. That when there are different rules that we have to adhere to, and I don't have anything in front of me. But whether it's, how many people are on this board, right? How we go through these hearings, different situations like that, right? This is a legal thing. So being the attorney for the town, is that in your purview to look at all the rules for the different boards and committees to see if we're following processes that are legal or no?
Overturned, sure. But in essence, Mr. Sussman is the board's lawyer. Okay, so
understand.
in essence, on just to make sure that indeed things are not unusual, sure. I've reviewed all the rules for all the administrative boards, in the town, sure.
Okay. Well, because you stated that whether there's 3 of us that vote or 5 of us that vote, it's all wrong. So that implies that the very basis of our being is flawed.
No,
And I'm just
Mm.
wondering how then are you interpreting that whether it's 3 or 5 are wrong?
oh,
on
no,
voting?
no. If indeed there was evidence which was been presented, then in essence, because a couple of members didn't make proceedings, then yes, it would be 3 that would have to make the decision, okay? Because, and Mr. Sussman and I discussed it early on, because in essence, the code does not permit you to go watch it on the videotape, okay? But the problem is that now, when they, in essence, I've changed my mind for that almost, 30 some hours of, was it testimony or evidence or whatever it is? What was it? I don't know, okay? But what's important is we don't know what it is. So in essence, you're not held by that standard anymore. Because in essence, we don't know what evidence or testimony came in, didn't come in, was applicable, not applicable. Nobody knows anymore because that's the way the hearing proceeded. Now, the question is, because we don't know whatever that was, where does that leave the board? I don't know, okay? And I can tell you one way or the other, who knows? And I can tell you, I've never heard of a situation in which what happened. Never even heard of it. So in essence, however happened, then I would say part of that's going to have to be, yes, we have the ability to vote this way, but I can tell you it is not going to be enforced one way or the other. Okay, and I was going to say it's going to have to be some type of appellate judges come up because I've never even heard of a case like that.
Great. Thanks for the clarifications.
Any further questions, Mr. Pounds? Okay, thank you, Mr. Pounds.
Okay, and I can tell you, Mr. Chair, I'm somebody who believes in being open. We're gonna have another hearing on what I think is the 13th. If somebody has another question, I'll answer it. Okay, I'm not gonna sit there and say, this is it, it's all done. I'm here, I'll be available.
Works. Okay, is there any other business? Actually, no, let me.
I have a point,
Go ahead.
if you're ready to
Yes.
hear it.
Yeah.
So there was a lot of discussion about an issue. There was a lot of discussion just now about an issue that I have no idea what it is and why it's being talked about. And apparently there's been discussions outside the context of this hearing about the number of people who can vote on this thing. That was never brought up and discussed, and you haven't heard my input on that point. So what are we talking about? Apparently there's some issue that hasn't been part of the record.
This is a proceeding issue. I'll ask Mr. Sussman, would you like to summarize?
The issue, Mr. Bliss, is that under the town code, a decision of the board has to be made by a majority of the entire board who attended the proceedings.
And just for clarification,
So-
Mr. Sussman and I haven't had any ex parte communication. He was sitting up there and we said, how many the number? And I looked at him, I said, 3, and he nodded. So that is all the discussions he and I have had on it.
Okay, so at some point, I'm going to do my opinion on that issue, or do you not even need my
No,
opinion?
I welcome it. I welcome Mr. Blitz's opinion and send me a copy too. So I can review that. So yes,
I'm not going to provide it in writing. I'm going to provide it to the board in an open meeting.
Maybe have
At
it
the next
provided
meeting?
at the next meeting.
Yes, that's what I would suggest. What provision of the town code? If you don't know, then I'll look.
I don't have it right here in front of me.
It's somewhere in the board's, describing the board's authority.
Yes.
Thank you.
Okay. So we are announcing the next meeting, which is November 13th, 2024 at 6:30 PM. Because we have concluded the town's presentation and questioning, this session will be a dedicated meeting to receive public comments. If members of the public would like to be heard, then November 13th, 6:30 PM is when they should attend. That is all we will do during that particular session. If it's 5 minutes, if it's 5 minutes, if it goes on, it goes on. Okay. Is there any other business before the board at this time? Hearing none, I'll entertain a motion to adjourn.
I will make a motion to adjourn.
Second?
Second.
All in favor?
Aye.
Meeting's adjourned. Thank you.
Here.
Presuming that we're going to need a December meeting.